Morning, everyone. I feel like I'm in a dark cave here. Please do let me know if you can't hear or want me to repeat anything. So we're going to talk a little bit about adapting to the changing regulatory environment. Slides aren't working over here. Is there any way of getting it up on the computer as well? Does anyone know? So the objective today, what I'm going to talk about, I don't have that much time, but I want to give you a little bit of an idea about the changes that are forthcoming and how to prepare for CQC inspections. Just out of curiosity, how many people here are providers or from providers? Oh, that's good to hear. So this is useful stuff for you. Yeah, how to prepare for CQC inspections, what to do during and after inspections. It's not working here now. Right. Sorry, there's a little bit of a technical problem. We'll be there in a second. Great, fantastic. Okay. All right, thanks. How to challenge CQC effectively. That's very important. Inevitably, even if you're the very best provider, because inspections and regulatory decisions involve an element of judgment, there's bound to be from time to time cases where the regulator gets it wrong and you need to challenge them. So a little bit about how to do that, and also to answer any questions you may have. I want to rush through my slides so that I can give you as much time as possible to answer the things that are really exercising you and important to you. So a little bit about what's changing. The CQC Strategy 2013 to 2016 was published earlier this year. David Beirne's taken charge of CQC, as you all know, and the strategy has been published. As we all know, it follows quite a lot of criticism of the regulator from a variety of sources for a variety of reasons. So in response to that, there's going to be, there already has been an appointment of a Chief Inspector of Hospitals. There'll also be a Chief Inspector of Social Care and Support, and also for primary and integrated care, possibly. Developing new fundamental standards of care, which people might have mixed feelings about, going from the regulations to essential standards to fundamental standards. I wonder what the next step will be. And this is, I think, a key one, actually, that making sure that inspectors specialise in particular areas of care and lead teams that include clinical and other experts, including experts by experience. I think one of the changes that probably baffled a lot of people when CQC came into existence was the idea of a generic inspector, somebody who was intended to inspect services ranging from a small care home of, perhaps 4 service users, learning difficulties, right through to NHS trusts, large acute hospitals. And of course, there's no way that one person would have the skills to do both of those. That's now finally been abandoned. There's also going to be national teams in the NHS. I won't talk about that too much. And CQC also wants to improve the understanding of how well different services work together. It's all about integrated care, really, moving between different services. There should be more information about, for the public, and crucially, ratings of services. That's quite an important one. We all remember star ratings essentially coming back in some guise or another. There's going to be a consultation which will launch on Monday, so keep an eye out for that, because I think most people in the sector would welcome quality ratings, but only really if it's done well, if it's logical, if it makes sense, crucially if it can be challenged effectively, because again it's a matter of judgment, and even the best organisations will make erroneous judgments from time to time. So keep an eye on that consultation and do respond. And also there's going to be some work around strengthening people who are detained. So I just thought I'd put together some headlines of what I expect the changes will be in terms of how it will impact you as providers. What will that difference be? First of all, as I've said already, expert inspectors. So we're talking about people who really do know the sector as well as you do. So they're not going to be fobbed off. They know what they're looking for. There's going to be targeted inspections again in the near future. And that's an inevitable consequence of limited funds to regulate a very large market. I think at the moment, of course, going through a process where all services are being inspected, but after that, CQC will target their resources on those homes that are failing, or other providers, of course. I think related to the cause of that is I think that there will be a focus on effective quality assurance systems. I think because CQC won't be able to be in every month or two checking that you're doing what you're supposed to, what they're going to want to be reassured about is that you as a provider have effective quality assurance systems so that you can work out when things are going wrong and you can take effective measures without CQC having to be looking over your shoulder the whole time. And rapid regulatory escalation. There was already a new enforcement policy which came into force already last year, introducing the notion of an enforcement escalator. And the idea of that was that the CQC wouldn't stay at the same level of enforcement repeatedly. They would take some level of enforcement action, and if the provider didn't come into compliance, then it would move to the next level of enforcement. And I think that we will see more of that. I don't think we'll see CQC issuing lots of improvement notices. I think it will go for improvement notice, warning notice, and really to notice of proposal to cancel. So for you as providers, that means that when there are concerns from the regulator, you have to take very prompt action to remedy it, to avoid higher end enforcement. So a little bit about how to respond to all of this. First of all, you need to know your sector inside out. As I said, the inspectors will know your sector inside out. So you must make sure you know it at least as well as them or better. So, for example, something that comes up quite often at the moment with CQC is staffing levels. You need to be able to show that you know what the industry standards are, you know what guidance documents are out there, what tools there are for staffing, so you can show CQC that when you made a decision, it's an informed decision based on real in-depth sector knowledge. Oops, sorry. And robust quality assurance systems linked to the essential standards. I think that's essential. I think most of you will remember the brief use of AQUA requiring every provider to essentially complete a questionnaire before CQC inspected, which was linked directly to the essential standards. And my view, and a view of a lot of commentators, is that actually that was quite a useful quality assurance tool. And even though it's not mandatory anymore, it's a useful way of ensuring that you're compliant. You must have systems in place where you're judging for yourself whether you're complying with the essential standards before CQC knocks on your door, and that you can evidence it. So for every judgment that you're making, that you can show that you're compliant. So that when CQC does ask, you can show them. And nip problems in the bud, that's related to the idea of an enforcement escalator and CQC taking more robust action if there's not immediate compliance. So as soon as a problem, you spot a problem in a home, that's the time to act, immediately. I've got a client at the moment that, where there was, eventually the home closed, and looking back through the internal correspondence of this provider around the home, there was months and months of correspondence between the middle and senior management around concerns about the home. And really, from the very beginning, when it first became a problem, that was when control had to be taken and every effort made to come into compliance. A little bit about how to prepare for an inspection, because we're all inspected from time to time. So this is the point that I've really been seeking to make a little earlier. Those of you who have robust quality assurance systems will always be ready, because you'll always be able to show that you're compliant from your own internal audits. And the idea of all of that is to discover your weaknesses before CQC and other stakeholders. Because of course there's a range of other stakeholders. There's the service users themselves who can complain, and so can their residents, so can their relatives, so can other professionals who work with them. You've got local authority commissioners possibly. safeguarding. There's a whole range of different stakeholders who have an insight into your business and who are able to raise concerns. And you want to make sure that you discover the problems before those stakeholders do. And crucially, you need to ensure that compliance is underpinned by evidence. For every question you ask yourself about whether you're compliant, you need to also be asking yourself, how can I prove that? What evidence will be useful here? If you come up with the answer, I can't think of any evidence, then you've reached the wrong answer. You need to be thinking harder. CQC will be looking for evidence, so you need to be looking to show exactly what it is that's required to show compliance. About during an inspection, sometimes we do have problems with inspections. I mean, it's not that common, but it does happen that providers take umbrage at the way the inspectors are inspecting. That perhaps they're not looking at documents that they ought to be looking at. They're refusing to look at things. They're being rude to staff. It does happen from time to time, and you need to know how best to avoid it and how best to challenge it. The starting point is take very careful notes at the time. A contemporaneous record is going to be all that much more credible if it comes to a dispute about what happened later on. So take careful notes. Ask whether the inspector needs any further documentation. Before the inspector leaves, you might get some feedback in which the inspector points out that he or she has concerns around a particular area. At that point, perhaps you can ask what other documents they want to see, or you can suggest at that point other documents that they haven't seen. Because after all, if you've done the quality audit on a regular basis, you know what evidence can demonstrate compliance. So you should be able to bring it to the inspector's attention. Incidentally, if the inspector looks like they're going to leave without giving you feedback at all, do ask the inspector for feedback. The inspector's handbook does point out they should give feedback and that there should be no surprises in the inspection, so do ask. I think it's really important to be helpful, obviously. You want to provide as much information as possible for the CQC inspector to reach a judgment that you're compliant, so be as helpful as you can. And as I've said, ask for and take notes of feedback and respond to it immediately if there's some concerns around particular areas. Provide the evidence to assuage them then rather than waiting till later on. After an inspection, complain promptly if appropriate. So if there have been concerns around the CQC's conduct, inspector's conduct, the time to complain is straight away. That's much more credible than waiting for a report, which turns out to be critical of you, because then some people might say that it's just sour grape. So complain promptly. Remember, you've got the notes, so you've got the evidence to show it. Send any further documentation. If there are things that the inspector couldn't find, or indeed you couldn't find at the inspection, provide them shortly afterwards. CQC has a general public law duty to take into account all relevant evidence. So the idea that the gate comes down when the inspector leaves is, certainly from a legal perspective, wrong. When you get the draft report, read it line by line. Take note of any judgment at all that you disagree with, state why you disagree with it, and provide evidence. And that's the best way to respond to draft inspection reports. You have 10 days within which to do it. And that's the way to do it. Read it thoroughly, line by line, note what you disagree with, state why, and provide evidence. Don't miss deadlines if possible, obviously. A bit of common sense there. Just a very quick thing on warning notices, because they are extremely common. I mean, thousands of them have been issued by CQC in the last few years. CQC was publishing them routinely. It was publishing information about them and press releases about them routinely. And that's currently under review, I think partly perhaps because we pointed out that they weren't really exercising a discretion. They were doing it literally as a matter of routine. They were publishing virtually all of them, something like 99.9%. I mean, a ridiculous amount considering there's a discretion around it. So At the moment, I think they're not publishing until they've conducted this review. But if you're commenting on warning notices and making representations about why they shouldn't be published, comment on any of the facts you disagree with, again, using the method that I set out earlier about saying why you disagree with it and providing evidence. But also comment on other reasons why the notice shouldn't be published. So, for example, one thing that I think is really crucial is if you say, if you accept that there was a fault at the home, but that you've remedied it, my view is that that's a very good argument why it's no longer appropriate to publish information about the warning notice. And I think CQC will change its stance on that. They disagreed, but my gut instinct is that they will change their view on that. Because plainly, the case for publication has got to be stronger in a case where somebody hasn't taken any remedial action. In fact, perhaps hasn't even acknowledged that they were at fault, than in the case of somebody who acknowledged exactly what was wrong, took immediate action. So do comment on improvements. And do seek advice about higher end enforcement, or indeed any of this on warning notices and comment on draft inspection reports. It's something that we do at Ridouts, week in, week out. So we do have the expertise that comes from specialisation. So yeah, I thought I'd like to leave a little time for questions about anything really to do with regulation. We also do a lot of work around safeguarding, so if anyone's got any concerns or questions around safeguarding, then I'm happy to take some questions on that too. Anyone who's going to go first? Yeah, is there somebody coming around with a mic? I think there is. So somebody's going to come just to the front here.
Yes, have you launched any judicial review against CQC? It does seem to be the only way of appealing ultimately if they remain steadfast, because they're reluctant to prosecute because their other powers can in effect close your business down. So
yes, indeed.
Why bother prosecuting with the problem of having to prove things beyond reasonable doubt when it's so much easier to publish a damning report or take other action that just closes you down anyway. So it would appear that judicial review might be the only way of proceeding, and I just wonder whether your firm has had any that have actually gone all the way to court, or do the CQC back down?
Can I ask where you're calling from? Where you're asking from? You're providing...
We run a domiciliary care agency in Leicestershire.
Yeah.
I happen to be the company solicitor.
Right. Yeah.
I'm picking your brain.
No, you're very welcome. First of all, you're absolutely right. The CQC hardly prosecutes at all, a handful a year, and I've not looked at the recent statistics, but I imagine most of those are for unregistered services, for services carrying on regulated activities without being registered. So you're right, they don't prosecute, and for exactly the reason you say. It's a high threshold to overcome, and they've got ample powers to close services down. Having said that, judicial review is not the only remedy, and is not in fact the usual remedy. If CQC is going to close a home, the method is that it will issue a notice of proposal to do that, except in urgent cases I'll come to in a second. And providers have a chance to make representations on the notice of proposal. And if CQC then goes on to confirm its decisions and to cancel, there's an appeal to a tribunal. So there is a specialist tribunal, so you don't have to go to judicial review. And we have had cases that have gone to tribunal, and we do tend to win them. But we also tend to win before we get there, because one of the things about the process is that CQC has to keep on considering its decision at the time of the decision. So if there's been a long history of non-compliance and then they're proposing to cancel, then the best strategy might be to do everything possible to come into compliance and to evidence that, so that when CQC makes its final decision, it's no longer appropriate to cancel. And that's a strategy which tends to work best. In terms of urgent cancellation, there's a hearing at the Magistrates' Court in the first instance, and again, the appeal from that lies to the tribunal, so there's no need for judicial review. So there'll be very few cases that will be about judicial review, and those will be more things like some use of its enforcement powers that aren't subject to appeal, inspection reports which are just balmy, that sort of thing.
Yes, that's what I was thinking of, because that can kill your business off.
Yeah, I mean, it's very difficult with inspection reports because the courts are inevitably going to give quite a lot of deference to judgments of a regulator. So the hurdle's quite high. But if you can show that they've not taken into account relevant evidence, or they've taken into account irrelevant considerations, then it's certainly an option. It'll really depend on the facts of the case.
Thank you.
Will you tell us where you're from? And
Amar Majara, Peterborough Care. We operate care homes across Cambridgeshire. Jonny, just a quick question. I was speaking with Frank Ursel from the Registered Nursing Home Association last week, and in particular regarding quality assurance systems. And he said that he'd heard off the grapevine that there was due to be a revamp of the essential standards of quality and safety. Are you aware of any of those changes that are coming about?
Well, really only what I've just told you now, that there's going to be a move to fundamental standards away from essential standards. But as to the precise details, I don't know. No doubt there'll be ample consultation about it. And it's certainly something to keep an eye on. Yeah. Any other questions on anything from my talk or anything around safeguarding or regulatory matters generally? Don't be shy. Here's some time for some free legal advice. Don't get that very often. All right, well, I sign off then, I think. Thank you very much.